I don't know. After hearing him calm and talking about the tether story, it's probable.
Let's go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
I was late. What's going on? This is Colin. How's everybody doing? Happy Sunday. Happy Sunday for everyone that's not a Bengals fan. Tough day for us. Congratulations, Steelers. Hurts me to say that. Congratulations, Steeler Nation. You guys, first game over 400 yards in 40-plus games. Fired your offensive coordinator. Yeah, you guys looked amazing. 400 yards. 16 points. Keep up the good work. All right, enough about that. Who wants to watch some court? Hello, everybody. I saw a lot of names. I jumped in. I saw Leanne, Nancy, Christy, Hey Jay, Heather, of course, Heather, Phil, Mari, welcome. Is it Mari or is it Maury? Mari? But thanks for coming. I appreciate it. I know there's a lot more names. I'll get through them. Sally, I saw Sally was here. We'll get through that. I spent pretty much all morning cleaning my hard drive, compiling all these videos. So I've got a lot of videos ready now. So there's going to be a lot of times where I don't know what's on the video because I compiled them all this morning just so I had them ready. I wanted to clean my hard drive up. Had almost 60 just court videos that I need to put into videos I could stream. So that's what I spent a lot of my day doing today. Hope everybody's well. This first one, I will warn you, I really like this judge. I just love his voice. He has that really deep voice, and I really like it. His audio is terrible. So if you don't have headphones in, you might want to put headphones in, turn your volume to the max, because this is a really interesting case. And the defendant, not really that nice of a person. But before I do hit the play button, you know what to do. Like, subscribe to your Jump Kick Backflips. And if you'd like to donate, please and thank you. Someone commented in a comment, yeah, they don't say please. I would say I would appreciate it, but I don't say please. And they're right, I don't say please. So maybe this will help. Please and thank you. I would very much appreciate it. All right, who wants to watch some court? Let's go.
23-1001, People versus Alvin. And so the record.
Good morning, Your Honor. Elena Cisneros on behalf of the people.
Good morning, Your Honor. Rita Rossin on behalf of Ms. Alvin, who is present in the courtroom and standing to my left. Today is the date and time set for sentencing, and it is
Actually, we're a little late, aren't we?
It is. It was originally scheduled at 9:30 this morning.
Ms. Alvin, you were late before, weren't you?
I was.
I explained to you that that's not acceptable. So, I had an opportunity to review the risk assessment, have you?
Just going over the record right now.
I was actually speaking to Ms. Rothstein.
Yes, I have reviewed it, and I did speak with Ms. Alvin. It's my understanding that Ms. Nichol emailed her a copy of this assessment at least last week. And on speaking with Ms. Alvin, she did tell me that she felt it was factually accurate.
Is that true, Ms. Alvin? If you'd like to allocate, go right ahead.
Thank you, Your Honor. We would ask that the court adopt the recommendations that is in the assessment, containing the assessment for the 6-month probation. We feel that Ms. Alvin will benefit from the supervision and the services that probation provides. And it is also my understanding that Ms. Alvin does receive Medicaid insurance. Is that correct? So we would ask that in lieu of
Have you
that.
been exposed?
No, it's Bethany. One of my coworkers is sick. She doesn't have COVID, but she has some sort of. And I just try not to get it.
Say crud.
I called it crud.
I can't really hear you clearly with the mask on, so I was just
I
wondering.
can take it off.
You can keep it on, but I wanted to make sure I understood what you said.
Yes, so we would ask for the 6 months probation, and that we believe that Ms. Alvin will benefit from the supervision and services that probation will provide, and that she is receiving Medicaid benefits. So if she could get some sort of discount or break on her fines and costs, that would very much be appreciated.
Okay. Ms. Alvin, this is your opportunity to speak on your own behalf.
I don't know what I'm supposed to say.
Whatever comes to your mind. There's no script.
I agree with that. I agree with that, attorney.
Mr. Smith, if you want to mention your appearance.
Yes, Your Honor, Elena Cisneros on behalf of the people. Good morning.
Good morning. So you have a distinct advantage over Ms. Ronstein. You were there for the trial and because you would like to sort of weigh in.
Yes, Your Honor, not only given the case, but given the victim's communication with my office, I did want to make a statement on behalf of the victim who was unable to be here today, if I may.
Sure.
Thank you, Your Honor. She did request that I read the following. Being attacked by a stranger that was stalking me prior to this incident is very unfortunate. I was assaulted in front of my disabled daughter. My daughter now has even more trauma to deal with. I feel the accused defendant should get jail time. I've been through a lot worse than her, yet I still managed to not attack anyone. The defendant had no regards for her children or any children involved. I feel the accused does not truly care about anyone, including her own son. The accused is teaching her son to attack others. I feel the defendant should receive counseling and should get lessons regarding child care, because the defendant is seeking violence as a way to handle things. I believe she should get jail time and probation. Thank you.
Did you have any of your own sort of personal?
Your Honor, from the people's position, the video speaks for itself. I think that it's pretty daunting. The actions that were not only observed on the video, but also the individuals that were around in that video and those people that observed it. I'm concerned about the other areas in Miss Alvin's life, if this is how things are handled in front of not only to another adult, but as well as in front of minor children, the people that we're supposed to be setting the best example for. I'm concerned with her actions, and I do feel that probation as well as some sort of upfront jail time is appropriate.
So let me ask you a question, because of it was necessarily part of your trial strategy, but certainly at one point there was discussion about what actually happened between Ms. Alvin and the police officer. And there was body cam that you decided to introduce as part of the discussion that the police officer had when he was doing his subsequent investigation. And I was just wondering in terms of, but basically, I guess I'll use a sort of a big word, the calcitrance of the defendant would seem to indicate that it just extends to anybody and everybody that seems to get into her orbit, including state license professional like a police officer. So
Yes, Your Honor.
I don't know if you wanted to speak on that a little bit, since I gave you that sort of opening.
Your Honor, I don't disagree with the court. As the court is well aware, from my professional standpoint, it's unfortunate that I see that sort of reaction a lot to law enforcement. However, I would agree with Your Honor that that was not only visible to the victim in this case, but continued on through her dialogue, if, for lack of a better word, with the officer.
So, Ms. Alvin, I'll give you another opportunity to speak, since there's been a lot said about you that you didn't have a chance to address.
I don't believe I deserve jail time, probation and counseling.
So why don't you think you deserve jail time? Jail time is considered to be for a punishment.
Um.
So remember this, you've been late to court twice.
Yeah.
You got into a situation that should have never happened with you, where you beat her senselessly. You were confronted by the police about what actually happened. The video of you and the police officer is very unflattering in terms of your attitude towards him and what it was that he was trying to investigate, and even the way you spoke to him was a whole lot of disrespect. It seems like there's just a whole lot of disrespect for the entire process that you caused to unfold for no good reason that I can see from looking at the video. So if you don't be punished, if you're not punished as a consequence of this, what would punishment be?
No, I guess, because this is what happened. I mean, this is my sentencing date. I haven't been into any altercation.
I'm not gonna send you to jail for a long period of time, but I think that there has to be some jail time. There has to be some limitations on the person's behavior. And I'll go back to what Ms. Lewis said about you and the children around you. You were encouraging your son to engage in the same behaviors that you were engaged in. That all of this happened in a situation that it should have never happened. There was no reason for there to be a fight, and certainly there was no reason for you to act out in the manner that you did. You should actually be embarrassed by that, to do that in front of your son and teaching your son those same sorts of behaviors is not going to, it's not going to be well for him. It's not going to serve him well. He thinks that he can solve everything with his fists.
Yeah.
Go ahead.
I try to teach my son to walk away and not to put his hands on anybody.
This was a failure, a pretty clear failure. Listen, I am not some sort of therapist. I'm not a parenting guru, and I only know what it is that I know. I'm sure that there are a lot more people that are smarter than me about parenting. But it just seems to me that it was a serious disservice. All right, I am going to order some probation. I am going to order some jail time, but as I said before, I'm not going to order a lot of jail time because I think that if I order a shorter period of jail now, I'll have some left if you don't learn from this experience. And if I have to, I will be sending you back to jail. But I want you to know that I'm serious. Despite the fact that I'm sitting here speaking in a calm and unemotional tone, I'm very serious about how I do my job. And I think that you probably already know that. Just thinking about your son when he threw those keys on that seat and made all that noise. When your son came in and he threw the keys on the seat, when he came to sit next to you, the very first time you were in his courtroom. I have this bad habit, I don't forget things. Don't forget anything.
I did. I forgot to hit the like button. Thank you for reminding me.
Because I had raised my voice with him.
I wanted to say something, but you had already said it, so I guess that you continue.
Well, you put him in check. After you put him in check when he was still out in the hallway, because I don't know what he was doing in the hallway, but I saw that you spoke to him and you made him come into the room. And that's when he threw the keys on the seat. All right, I'm going to order that there be no fines and costs. We're going to find that she's indigent for the purposes of fines and costs. Probation's going to be for 12 months, but I'll give her an opportunity to cut that in half if she can successfully complete the terms and conditions of probation. The terms and conditions are really tempered by this, and that is rehabilitation. Rehabilitation means that you change everything, so that you change your actions. And if you don't do that, not only are you not going to get off probation early, you can be on probation for up to 24 months. I'm actually giving you an incentive to understand just how serious I am about this, and that you have an opportunity to change how this is going to play out. If you apply for early discharge of your probation, I will be looking at the case again to determine whether I believe that there actually has been a change, a fundamental shift in who you are. But understand this is not about me, it's not about the probation agent, it's not even about the court. It's about the way that you live your life. In other words, probation and the rehabilitation goes along with it. It's about you. And it's not something that you just do so that you can stay out of trouble and get off of probation. It's something about how you actually change, how you think, so life is different. That's what real rehabilitation looks like. A fundamental shift that you don't stop because you've gotten off probation. Because you see the error of your ways and that there's really reason for you to continue to be rehabilitated. Because you see the significant change that occurs in your life and the life of your son. So, you're not to possess, carry, use, or purchase a firearm, ammunition, or other dangerous weapon. Do you own any weapons?
No.
You're not to violate any criminal law of any unit of government, not leave the state without the prior consent of the court. You to make a truthful and accurate report to the probation officer at each contact. You to notify probation within 24 hours of any change of address or employment or school status, and within 24 hours of any contact with the police. And when I'm talking about contact with the police, I'm talking about official contact with the police, like being arrested or being detained and questioned by the police. I'm not talking about situations where they say, hi, how you doing, or something like that, or if they're directing traffic. I'm talking about situations where they're likely to put your name on a report. And if you don't know whether this is a situation where they're going to do that, you need to always, always, always report it. Because if you fail to report something that turns out to be reportable, you go to jail as a probation violation. So you need to treat almost every situation like you have to report it, unless it's somewhere they're just saying hi to you or something like that. Report it, because you can go to jail. You provide proof of healthcare coverage or meet with the healthcare navigator as directed by probation, and you to meet with your probation officer on a monthly basis or as directed. You're not to possess, carry, use, or purchase any firearms or any other types of weapons. We didn't actually go through that. Well, do you own any weapons at all? Not to use, possess, consume, nor be in the presence of alcoholic beverages or controlled substances, nor be present in any place where alcohol is sold for consumption on the premises. You're not to use any products that contain alcohol or some other substance that would change the state of alertness. So I said before, probation is about rehabilitation. Certainly there are environments that are not rehabilitative in nature. And probably the principal type of environment would be a bar. So as I said, you can't be around people that are drinking and you can't drink. And you can't actually be in a bar, even if you don't have the intentions of having a drink. So you might want to go to the bar because they sell good food. Maybe you don't even plan to sit there and eat the food. Maybe you just want to go in and give them your money and turn around and leave. That is still a violation of probation. Just walking through the door of that establishment is a violation of probation. Going to a bowling alley, same thing. You might be there to bowl, but It's a place where alcohol is available. So since it's a place where alcohol is available, you can't be there without having my permission, probation officer. Going to a restaurant like Red Lobster's, Applebee's, or Chili's, the same thing. And even though those places sell food, and maybe you're hungry and you're not even intending to be around people that are actually drinking, maybe nobody's actually drinking in the restaurant, it's still a violation because alcohol is available for consumption. Going to a wedding reception, going to a concert, going to a sports stadium, going to a movie theater, going to tailgate event. Those are all places where alcohol is potentially available. So you would have to have permission in order to be there. Not only can you not be around people that are drinking, you can't be around people that are using controlled substances, and marijuana is a controlled substance. And the law has changed, and people over the age of 21 can now legally possess and use marijuana. But I treat it the same as I treat alcohol. It's not a rehabilitative environment for you to be sitting around in a cloud of secondhand smoke. And even if they weren't smoking and they had edibles, it's still not a rehabilitative environment while you're sitting around while your friends are getting buzzed. And obviously, if you can't be around people that can legally use controlled substances, you can't be around people that are illegally using controlled substances. You can't use any substance that contains alcohol or some other substance that would change your state of alertness. And alcohol is hidden in a lot of products. People actually have been known to drink stuff like hand sanitizer, rubbing alcohol, sternal fluid. People even have things like rubbing gasoline and dust. Alcohol is hidden in things like.
This is a really long speech, and I know that. He's walking her through everything she can and can't do. The guy that I showed yesterday, which was the quickest bond violation ever, if he would have gotten this speech, he may not have violated. And I love this judge's voice, so we're going to finish letting him talk. If you haven't liked and subscribed already, why not? The buttons are right below. Thanks, please, and thank you. I gotta get better at saying please.
Non-alcoholic beer. Non-alcoholic beer actually has alcohol in it. There's alcoholic things like cold medications like NyQuil. There's alcoholic things like mouthwash like Listerine. And then beverages like Mike's Lemonade and these twisted teas and salty waters and even energy drinks like Four Loko. So you have to know what it is that you're putting into your body, because what you put into your body will land you in jail. So apply to you as well. You could not have exposed yourself to brownie or something and say, oh, I didn't realize it had THC in it. So you, what it is you're putting into your body because you're comfortable with that. So brownies, cookies, gummies, granola bars, suckers, dabs, wax, vapes, cages, salvia spice, 221 cloud nine, potpourri, or whatever it happens to be. It's a violation. You're not going to use prescription and non-prescription drugs and provide verification about prescriptions to testing to your probation officer within 48 hours of obtaining the prescription. You're to attend counseling as recommended in the risk assessment device. You're to drop for probation, law enforcement, testing agents, case manager, physician, or counselor. You to submit to a search of the person, your home, or your car. Upon the request of either probation or law enforcement officers who have cause to ensure that you're in full compliance with all probationary terms. And if you get placed on electronic monitoring, and I'm not placing you on electronic monitoring, but if you get placed on electronic monitoring, it does have GPS capability. Tell us where you've been geographically as well as whether you're in compliance with your curfew. And you will have an 11 o'clock PM curfew. 5 days community service by the end of probation, which is 40 hours. You no contact with Ms. Margaret Lewis. You're not to be on her property, not to assault, harass, intimidate, beat, molest, or wound any person. You're to keep domestic peace. You maintain employment as a condition of probation. You attend parenting classes as part of this process. And you submit to fingerprint by law enforcement as direct by probation. I'm ordering that you serve 14 days jail with no tether and no early release without further order of the court. Now, despite the fact that I've ordered all these things, you may be able to appeal. If you decide to appeal, you need to do so within 21 days. You require the services of an attorney to help you with the appeal, and you can afford to hire your own attorney, then you need to let the court know within 14 days. So we can refer your case to the Office of the Public Defender and they can evaluate you for eligibility for public services. Yes, Ms. Snell, any questions or concerns?
No, Your Honor, thank you.
Ms. Robertson,
No, Your Honor, thank you.
Ms. Alvin,
I don't understand. You said 14 days and then 21 days. What is that?
14 days jail, 21 days to appeal.
To appeal the jail? What am I? But,
To appeal the sentencing.
oh, okay.
Jail is only a part of the sentencing.
Okay.
Okay. So you're gonna go with that nice lady?
All right. I didn't want to pause it too much. That was a serious case. Hey, Monkey, how are you? But before I do get into the next clip, I do want to thank the super chats that came in between yesterday and today. Craig, I don't know who you are on YouTube, Craig, but I see you a lot on the super chats. Thank you so much. You're quickly coming to the #1 spot in my supporter list. You're getting really close. Also, Terry and I just looked. I feel horrible. I just looked and Willis. Sorry, I'm so sorry. I wanted to be able to rattle those off like I just looked because I did, and yeah. Anyways, thank you so much for the support. If anyone else would like to support, Heather just posted the link. It's also in the description. I actually may not have put it in the description. Now that I'm thinking about it, I didn't copy and paste it in the description, so I have to change that. So I will do that. Please and thank you. All right, next clip. Next clip's the last one on this video. If you guys want another video after this, generally I stream for about an hour, and this video is only about 30 minutes long. If you want another clip, let me know. We can keep playing. I'll play at least well, just one more. I'm not going to do one more than one. But this one happened today. Let's just say, stop arguing with the judge. Don't argue with the judge. That's all I'm going to say. I already have one. I'm going to jump off camera.
Prosecutor order number
23-10431,
the people versus D'Angelo, Huddleston, Mitchell. This is the date and time set for arraignment. Counsel, your appearance.
Good morning, Your Honor. Christopher Sakeley, bond number 23248, with the Michigan Defense Counsel representing Mr. Mitchell for purposes of arraignment only with his permission. Is that correct, Mr. Mitchell?
Yes, it is.
Judge, we will waive formal reading. He would stand mute.
All right.
I can't hear you guys. It's an echo. We got an extra box in here, so I can't really hear you.
All right, hold on one second. I can fix that.
Okay, that's fine.
All right, the court will waive formal reading, enter a plea of mute on behalf of Mr. Huddleston Mitchell. Sir, I did receive the request for court-appointed attorney form that you filled out and submitted. Based on your representations, I do find that you are indigent, so I will appoint an attorney for you moving forward, okay?
Yes, appreciate you.
All right, you're welcome. Now, counsel, as it relates to bond, we'll take the state on behalf of your client.
He is 31 years old. He's single. He has 2 children. He's engaged. He's does plumbing work with Wayne Contractors. He's not on probation or parole. He just had surgery on his foot for hammer toe. He's scheduled to have his stitches removed tomorrow. I don't think he has any prior felonies. I would respectfully ask for a personal bond.
All right, and Sergeant, is there anything you'd like to state regarding bond?
No, Your Honor, he's been cooperative with us. Like I mentioned, he does have several current outstanding warrants for his arrest. A reasonable cash bond, Your Honor, would be what we request.
All right, well, I will note that I did just conduct the swear to for this matter. I do see, looks like there's 1, 2, 3, 4, 5, 6 warrants that are outstanding at the moment.
From Detroit, yes, for my just traffic tickets. And that's why I'm in the process of getting everything together now, Your Honor. And that's and far as my personal, I mean, far as my me having any cash is really kind of tight right now. My daughter's her birthday is December 7th next week as well. So I just literally just had to come out of almost everything that I had to pay for her birthday party. But I mean, I'm not trying to give any excuses or anything like that, but it would kind of be tight for, it would kind of be hard for me to, you know, come up with some extra cash while I'm sitting in here rather versus out there and can, you know, make some stuff happen.
All right, well, I will note that I do see the 2 traffic matters that you're referring to in Detroit, but you also have a warrant out of the 19th District Court in Dearborn, one out of the 34th District Court in Romulus, one out of
And all
other,
and Your Honor, not to cut you off, but all of those are old tickets that I just gotta tell them go up to the precinct and have them take out the system. Because if you can see, I don't know if y'all can, but I don't owe anybody. And it's not like they not gonna come give me like they not what do you call it? I don't know why is it still a warrant if I already took care of it. But like I said, they told me that I gotta come to the precinct and just get it clear from out the system. Because I actually have paid for that or either did time. The Romulus one, Dearborn, all of those. So I only got I owe Dearborn $40 just because it was like a fee to get to get it took out of my name. I don't know exactly what it was called, but all of those was taken care of. So if you can see that, you should be able to see it. Like, I don't know, and I'm mad that it's even still popping up. Like I said, I would just have to go take care of that, like literally soon as because I didn't even know it was still in the system of warrant.
well, you've also got, it looks like, warrant out of the 45th District Court, that's Oak Park.
Yes, yes.
Yeah, that was for failing to appear at your pretrial for a domestic violence charge. Nevertheless,
Yes,
okay, so there's look, I'm just gonna say this, there's 8 outstanding bench warrants, so personal bond is certainly not warranted. I do think that a cash surety bond is appropriate, so I'm gonna order bond in the amount of $25,000 cash or surety. I'm also
Your
going to
Honor,
order
I
the
don't
following
have that.
conditions.
I don't have that, Your Honor.
Then you're gonna have to either go through a bail bondsman or you'll have to wait and address bond at your next hearing. But
And even though I'm telling you that I don't like what is stopping me from being eligible for my personal?
You have 8 outstanding bench warrants.
I understand it, and that's what I'll tell you. It's not 8. I promise to God, Your Honor, you guys can call right now. Like they would tell you literally. Recently I just, like I said, because I'm in the process of giving my license, I have been calling up there. They would tell you that I have no tickets, no money I owe. I only owe $40 for Dearborn. I gotta call Romulus, just literally tell them to take it out their system because it's already took care of. And the only thing that I had was the Oak Park and the Detroit. Literally. So that's what I'm trying to figure out. Why is it making me look so bad?
Here's what I'll say. Then what you just admitted was that you still have Oak Park and you still have Detroit. I'm not going to change my mind. These warrants are still outstanding for whatever the reason may be. They are still outstanding. So I'm not going to change the amount of your bond as of right now. You are free to address it at your next hearing. But in the interim, your other bond conditions are as follows. You are to have no contact with any employee of Macy's. You will not return to any Macy's retail location. You will personally appear for any and all future court proceedings. You'll not leave the state of Michigan without permission of the court. You will immediately notify the court in writing of any change to your address or telephone number. You shall not possess any firearms or other dangerous weapons. I am placing you under pretrial services supervision, which means if you post bond within 24 hours of your release, you have to contact pretrial services and get enrolled with them. Their phone number will be listed on the bond form that you receive. Lastly, no new criminal offenses or activity. Mr. Huddleston Mitchell, do you understand the terms and conditions of your bond?
So what's my bond right now? 2,500?
25,000.
25,000?
25,000.
All right.
All right, your next court date, just so you're aware, your probable cause conference is scheduled for December 4th.
Judge,
at 9
wait,
a.m.
Judge, can I?
All right. I don't have my little icon up there because the defendant's in the bottom left and I keep covering his face. I don't want you to lose any second of his facial expressions. He's not happy. $25,000. What they say, he got multiple warrants out. I didn't read the probable cause statement from the officer, but he walked into a Macy's store with a Macy's bag. So he walked in with an empty bag, supposedly, allegedly. He put a coat and a couple pairs of sunglasses in the bag. Macy's is saying that he was trying to steal over $1,000 worth of merchandise. That's why he's in jail. That's why he got caught. So at least I don't think I played it. Did I play that? I don't think I put that part in there. If I did and I'm repeating stuff, I'm sorry. It's been a long day of mindless computer work today. All right. Allegedly. Heather, you're right. Allegedly. Hello, everyone I haven't said hello to. If you have not liked the video already, please like the video. And again, if you guys want a second video, I'll play a second video. But we got one for yes and one for no. No one else has said anything. So if it's a 50-50 shot, we'll just call it a night. I don't care. I don't care either way. That's just more videos for this coming week. All right. Let's finish this up.
So I gotta sit in here for 20. So I gotta pay. But Judge, what the are y'all? Man, oh
All I
God,
can say is you may be able to go through a bail bondsman who would be able to post.
that's still $2,500. I don't have that. I'm about to be sitting in jail for something and literally they raised the price up on the item. I'm not saying that that's a problem, but all this is just me getting wrongfully mistreated. And now I gotta sit in jail with stitches in my foot. I gotta what's going on? And y'all not being able to see that my warrants is took off. Like, why is all this happening to me? Why y'all can't call up there and call the precinct and
Sir, Mr. Look, I can tell you this. Your warrants are still in effect, okay? And they are basically all pickup warrants saying that they would actually pick you up and take you over to get arraigned on those charges. So you're probably gonna get those results while you're in custody. But
we just talked to them, sir. When I was on my way here, he called up to the precincts and asked them were they releasing me or were they holding me. Everybody said release because they know it's not nothing that should be keeping me in here, like literally. And I don't have no money to sit in here. I promise. Like at least can I might come up with a few hundred, like 300 maybe. But I'm telling you, I'm in a bad situation.
I've made my decision. Like I said, you have every right to address bond at your next hearing. Maybe you can get a bail bondsman to post the money for you or have somebody help you out, but your bond is not changing as of right now.
And so 25,000.
25,000.
And is that 10% or that's just a flat 25,000?
That is just a flat 25,000.
Are you serious? Your Honor.
Really? Sir, I'm very serious, and that is all for today.
Am I that bad of a person? I never even had nothing like this before. This is my first time even going through something like this. And y'all are doing me like my daughter's birthday is on December 7th. Like I'm really in here in a bad situation, sir. This is a terrible, like I'm not trying to make no excuses or nothing, but I could do better. All I need is just a chance, Your Honor. I swear to God, I'm not no bad person, none of this stuff. But this is really gonna kill me sitting here doing it and going through all of this stuff. Like I said, it's not. I understand that I made a mistake, but I'm not trying to do none of this. I'm not trying to avoid y'all. I'm doing everything the right way.
I can understand and appreciate that. Hopefully you can get all of your warrants and everything cleared up. You can get this behind you and you can address bond at your next hearing, which is on December 4th.
But sir, this is not me doing it the right way though. This is not gonna help me.
Hold on, Mr. Hulston mentioned this is not a discussion. I have made my decision. Honestly, given the fact that you have 7 outstanding bench warrants, I think $25,000 is actually extremely reasonable. So, and I can assure you that I'm not abusing my discretion by giving you a $25,000 bond. I've made my decision. I told you have every right to address bond at your next hearing. But that is as it stands today, and that is all for today. Your arraignment is done. And I really, truly do wish you the best of luck.
25,000, Your Honor.
Yes. I do.
So
yeah.
I can't get out of jail without a bail bondsman and $2,500 is what you're saying.
That's up to you. That's up to you, but that's all for today.
So it's nothing we can say, nothing that can make it at
Nope.
least reasonable. Can I get maybe $1,000? I can probably get my fiance to do that.
Sir,
like,
I'm not, I just said,
Mr. Mitchell.
I'm not.
All right, yeah,
That's it. That's all for today.
It's not gonna.
I've made my
it's not gonna
decision.
sound like
why would you do that?
I didn't do anything, come on.
You did. You just
No,
told
I
him that to do a cash. You just told
Yeah,
him.
because you got a bunch of warrants.
Bro, can you look at the warrants and see
Yeah,
what
I
they
did.
are?
Come on.
Are y'all
This way.
serious?
It's already done.
He came up.
Man, that's some punk ass shit.
All right. I wanted to stop it before my outro played. I've got a serious question. He just admitted to shoplifting during this arraignment. His defense attorney said nothing. The defense attorney just sat there and drank his bottle of water. Why wasn't his attorney stepping up to tell him to stop talking? I have a real problem with that. He literally said, "I made a mistake. How is that worth $25,000?" That's not. He's not gonna. This is not gonna go well for him. 7 bench warrants, broke the law. Allegedly, even though he admitted to it. That's why you have attorneys. Your attorneys should not let you talk like that. But because the defense attorney let him talk like that, I've got a video out of it. All right. let me put up the second video. You guys all said yes. So I'll play the other video that I meant to combine with this. But I didn't. Let's see if I clicked the right one. I don't remember what's on this, but we're gonna get my intro again. I know we are talking about the tether story. We'll fast forward through the intro. Oh, this is a good one. All right, I know what this is. Sorry. Hold on. No. I don't have this opportunity very often. Let me do it. What's going on? This is Colin. How's everybody doing? Happy Sunday. Kind of want to redo my entire intro again. The Bengals lost. Darn. The Steelers won. They played a better game. All right. Do jump kick bat flips, like and subscribe. Link trees down in the description. And of always, Heather is posting it like crazy. Please and thank you if you'd like to donate. I spend a lot of time on these videos. All right. Now, this, you know what? I don't have to say much about this. This is back-to-back hearings. This is a couple weeks old. I think the first hearing is about 2 weeks ago, and then I have the follow-up hearing that was last week at some time. But this is a good one because we all love Judge Washington, and even more so, we love Prosecutor McDuffie. And she comes out in this, and it's a good. Let's go.
State of Michigan versus Crystal Gellermino, case number 23S00511. Rachel McDuffie for the people.
I'm here, Your Honor.
Hi, Hayden.
Yes,
Good to
please
see you.
state your name, Gellermino.
Crystal Lorraine Gellermino.
Thank you. I think this will be Ms. White's case.
Assistant Public Defender Sandra White on behalf of Crystal Gellermino. I don't see this on our list.
Hey,
What's the
Mimi.
last name again? Gellermino.
Ms. Gellermino has an active warrant for her mini bond
We're
violation.
gonna have to adjourn to get some discovery and talk to Ms. Gellermino. Can I get the case number again?
23S00511 is the case number. The warrant is still outstanding because Ms. Gellermino still has a $50,000 cash security bond. She's at multiple alcohol violations, and her alcohol is a factor in this case.
Can I
So-
speak on behalf, Your Honor? I apologize.
When she got arraigned, the magistrate did not withdraw the warrant because I didn't want it withdrawn. So, having said that, I think you probably need to speak with your attorney and
I
let
did.
your speak on your behalf.
I do need to speak with Ms. Gelomino. I don't know if Your Honor wants to put her in a breakout room because I don't want to hold up the docket or set this for a show cause.
I'll put it over for 1 week to November 20th, 2023 at 12 a.m.
Your Honor, I just want
Right when they said breakout room, I instantly thought, oh, I didn't edit this part of the video. I edited the second part. So I thought we were going to miss some time, and I had to fast forward it. Luckily, I don't think that happens.
to quickly inquire before she leaves. Two things. One, Ms. Gelomino does have an amended complaint, so I just wanted to ensure that the court and Ms. White are in receipt of that for the corrected charges on this case. The second issue is that I'm not sure where Ms. Gelomino is zooming in from right now, but Ms. Gelomino made some representations to Magistrate Nelson regarding why she has absconded from supervision on that scram tether. She said that Community Corrections told her she didn't need the test and that she can turn it in and save herself some money and some other things. I do have Agent Casey on standby because I did not know if we were going to proceed with the full hearing today, if she wants to continue with those types of representations about what the situation is. If she is not currently, I guess the warrant is still outstanding. I was going to request that she be remanded actually, but
Just wait to hear what she did. This takes balls. And she somehow got away with it. Well, she didn't get away with it. She's in court. But the fact that okay, let's just go.
I just wanted to put that out there. And apparently we're not proceeding with the hearing today, but I just needed to clarify where she is and what things are with respect to that warrant.
The warrant until she comes in person. She was supposed to be here in person today. She just didn't do that either. So this warrant is outstanding. So no, I'm not hearing anything from her today. Technically, she's not in court. So I can put you into a breakout room with her, Ms. White, and I'll pass this. I will set it over for next week when she can come in person. If she doesn't come, she will still be.
Yes, let's put it over for 1 week so I can get in contact with her.
What I just said was I was putting you in a breakout room with her so you can talk to her.
Okay.
Oh,
Are we still
no.
putting it over for 1 week or no?
Yes, we are.
Thank
Did
you.
I cut that? Was I not paying attention or did I cut it out? All right, this is a week later. Did it say what she did? I know the prosecutor McDuffie said what she did. I don't know if I have that in that recording. I don't think we heard it. I'm not even going to tell you because she's going to say it again here, and it's wild. It's wild. But I don't think I did. All right, let's go. But this is another case of, is she going to jail or
I will
not?
call the case of the state of Michigan versus Crystal Gelomino, case number 23S00511.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Crystal Gelomino. Please stand, state the name for the record.
Crystal Lorraine Gelomino. Thank you. You may be seated, ma'am. In this particular case, you were arraigned before the magistrate on November 8th for several violations of your bond, including on September 30th, 2023, you tested positive for alcohol with a BAC of 0.054. On October 1st, one second. I'm sorry, on October 2nd, you tested positive with and that was, see, you missed your test on October 2nd, and then you tested on October 3rd at 2:06 a.m. and you were positive for alcohol 0.212. And then on October 3rd, you tested positive for at a 0.054, and then retested the same day 0.036.
She's on. All right. I don't want to. because we didn't hear what McDuffie said in the last clip, I don't want to give it away. But she's on probation. She's not supposed to have any alcohol. So she's testing positive for alcohol. Yes, they're not above the legal limit, but she's not supposed to test positive at all. But yeah, Rachel McDuffie's about to lay down the law of she's supposed to be on a tether. I'll say that much. She's supposed to be on a tether.
Do we have a report since October the 24th, actually? Is anyone here from probation? Ms. Straub or Ms. Johnson? Can you check to see if there's a new report for Ms. Gelomino since October the 26th? The last one I have shows October 26th. Do you have one?
Last I have is October 24th.
Your
October
Honor, I
24th.
can speak to that actually, but I'll let Mr. Arp go ahead.
You can, go ahead. She may not have the info readily.
Ms. Gelomino no longer has the device. When she was arraigned on the violations before Magistrate Nelson, she told him that she was told by the sheriff's office that she didn't need to test anymore and she could turn it in to save some money. So I did confirm with Agent Casey that they said that they do not do pickups of devices, but he did confirm that someone from the Judicial Services Group did eventually collect her SoberLink device. I'm not sure under what circumstances, but I do have confirmation that she no longer has, at least the one she was originally issued.
All right, thank you.
Your Honor, I don't have anything. I don't have any report except the one I have says October 24th, and it just said that she's fully absconded from supervision at that time.
Right. Apparently, she just turned the device back in.
Yeah.
So, with
all right, there we go. She told Magistrate Nelson, I looked for that. Magistrate Nelson deletes his stuff, not right away, usually the next day. I went back and I was hoping I could find that, and I could not. It was already gone. I wanted to see for myself what she said, and if Magistrate Nelson actually said, yeah, you can turn the device back in to save money. There's no judge or magistrate that says, to save money, we're going to take away this device that you've been testing positive on. But she somehow talked the sheriff's office into coming and picking it up, which they just said that doesn't happen. They don't come pick the device up. Now you know why she's in trouble.
respect to this case, ma'am, you have a right to have a hearing in this matter, at which time if it is found that you violate the terms of your probation of your bond, then you can have your bond revoked. You might want to have a hearing on this.
You like to admit to the drinking.
Not only that, I have to tell you that you also failed to test as you were ordered to test. So you just simply turned your device in as if you didn't have to test. So that is another part of the violation.
She did think that she was supposed to turn the device in, and when they picked it up, she thought that she was supposed to start testing, is what Ms. Gerald thought.
My real question is whether she's admitted to that violation or not.
To drinking, yes.
No, turning the device in when she wasn't supposed to.
We are not friends right now, Lucy. We are not friends. But congrats on the 16 points. You guys did a really good job. Sorry, that was rude. Hi, Lucy.
Someone reach out to me, Your Honor. Would you like to understand?
So is she saying she wants the hearing? I have only one question.
Okay.
A hearing? Or because I'm not trying to take an explanation to anything right now.
I guess as far as the device, she'll admit to the alcohol. As far as turning in a device, she has an explanation for that. So
my question was,
she would like to have a hearing on that.
Okay.
or admit with the explanation.
Which one?
No. Yes, you would like to admit with an explanation.
Ma'am, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. You may lower your hands. All right, it's my understanding, ma'am, that you're gonna waive any right to have a hearing in this matter, and you're gonna admit to the violation. Is that true? All right, so let's start with the alcohol first. Is it true that you tested positive for alcohol on September 30th, October 3rd, and then again on October 3rd? And that you simply just, I guess, stop testing after October the 8th. Is that correct?
Yes.
And then you turned your device in?
Yes.
All right. All right, there's a knowing and willing admission to the violation. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Ms. White?
Yes, Your Honor.
All right. What is this explanation that she has for turning in the device?
Ms. Yolomino says she got a call and please.
You can
correct me if
stand
I'm
and tell
wrong.
me, ma'am.
Okay, you said she can stand and tell you?
Yes.
Okay, go ahead. You can stand and explain to the judge.
The reason I didn't, can we rewind? The reason I didn't do my testing was because I was in a mental health facility.
When did you go there?
The 8th.
Okay. And how long were you there?
I was in the St. Joseph's Hospital until the
Until the 13th of October?
and then I went into the 23rd.
I'm sorry?
I went into another facility, Pontiac General.
On the 23rd?
Until the 23rd. They took me from the hospital.
Oh, they took you straight from, you say St. Joe?
St. Joe's.
To where?
To Pontiac General Hospital, which is now run by the mental health facility.
Okay. And how long did you stay there?
Till the 23rd. And then 2 days later, somebody left a voicemail on my phone stating that they wanted my growing machine.
So let me go back a little bit, please. You say that you were in St. Joe's from the 8th until the 13th.
Yes, Your Honor.
And then from the 13th until the 23rd, you were in Pontiac General.
Yes, Your Honor.
Then you came home?
Then I came home.
And then on the 25th or so, someone called and said they wanted the device back?
They did.
And who was that?
I don't have the information. I have to wait until my billing cycle to call back the numbers. Because he answered the phone, whomever the sheriff was. He said Sheriff, I want to say Sheriff Bryant for some reason. But I tried to look at what I didn't, my billing cycle, and it wouldn't let me.
So,
And I erased the message already, Your Honor.
so, you got a phone call. How did the device get back to whomever you gave it to?
They told me to stick it in my mailbox. to wrap everything up and put it in my mailbox. I had to go and do my patient something for my mental health, because that's when they wanted me to go to CMH that same day that he wanted.
Are you still seeing CMH?
I am twice a week.
All right. All right, thank you, ma'am. You may be seated. Ms. McDuffie? You're muted.
Sorry about that, Your Honor. So I think it's well known to the court at this point that Ms. Gelomino has a very, very severe drinking problem. When she was last here on a child abuse case with alcohol allegations as well, she failed to get the scram tether that she was ordered to. And when she was arraigned on that bench warrant, she informed the court that she said she had been in the hospital, which is why she didn't get it. When she finally got the scram tether on, which was required for her release from custody, she never reported for a download, and then the case was dismissed. And so we never had any results for her at all. And it appears that she was even drinking during that period of time, because she has other cases in other courts for things like public intoxication around the same time as that. Here, the violations obviously speak for themselves with the drinking events, but my concern is that we're here again, we never got any documentation for the last claimed hospitalization that she had. I certainly don't have any information on any facilities that she may have been at, whether or not she was ordered to go to those or required to go to them. And there's no communication whatsoever that I have any access to that would indicate that she has reached out to anyone and said, here is a situation with myself, my testing, here is where things are. I don't necessarily doubt that Ms. Gelomino went somewhere during the past month or two seeking some sort of help for herself, but we're not in a situation where she can arbitrarily decide, of course, to do that. With the SoberLink device, her agent is not Agent Casey, but Agent, his name is escaping me right now. Apologies, I can't think of it, but the one that she was normally assigned for oversight of the SoberLink, he was out sick. So Agent Casey was trying to help fill in some of the blanks here. And what she indicated when she was arraigned on this was that she was told she could turn it in to save some money. But it appears that even if she was told that much, it was not so much an offer extended to her that she didn't need to test, but that she had absconded by that point and was required to turn that equipment back in to community corrections, which I think is why they came to pick it up when they don't normally do pickups. I think that it was just a matter of them getting the equipment back because she had absconded. So my concern here is that we need documentation of where Ms. Gelomino says that she was. B, she needs to get back testing as soon as possible, because I don't know, she hasn't been in alcohol related treatment necessarily, but no matter what, we need to obviously, I think, keep close track of her consumption because she has a very serious problem. And I cannot take Ms. Gelomino at her word based on everything that I've seen. It's possible that I'll be proven wrong, and I sincerely hope that I am. But I feel like we've been here before. That's all.
Thank you. Ms. White, anything you want to say?
Yes. Obviously, Ms. Gelomino must have got some type of phone call because her device did get picked up. And it may be, I don't know the circumstances, and maybe it is, as Ms. McDuffie said, because she wasn't using it, maybe they do come pick it up. I don't.
That is true.
Okay, I don't know anything like that. I take Ms. McDuffie at her word. So she did get a phone call and it did get picked up, and maybe it was her misunderstanding that meant that she did not have to test anymore. Obviously, she hasn't been testing as regular as she should have been. She said that she was in the hospital. So I'm asking for an adjournment. I'm new to this matter with Ms. Gelomino. I'm asking for an adjournment so I can help Ms. Gelomino get back on track with her testing. She has been going to meetings. She did show me some documentation for that. Going to AA and NA. In both meetings, she has a sponsor. She reached back out to a sponsor. She has been talking to a sponsor again. And so I just want her to show herself and us that she can do what I know she's had plenty of chances. I'm asking this court for another chance, maybe with my help and some guidance, get back on the testing and someone to help her guide her along, keep her on track, because it sounds like she's got a lot of things going on and she's not keeping everything together. And it sounds like she has other issues if she's been in and out of the hospital that she needs to tend to too. So I would like this opportunity to work with Mr. Olomino to see what's going on, to maybe get her some treatment, because it sounds like that's what's really needed here. And to maybe get her some type of inpatient treatment for a while and to see if that's her best course of action. Thank you.
Thank you. All right, what I'm gonna do in this case is this. We're here today because she has a $50,000 cash assurity bench warrant that has been issued for her alcohol violations and for not testing. So we did not recall that when she was online. Let's see, she came online on November 13th when she was told to be here in person and she didn't come in person. So I give her credit for showing up here in person today like she was supposed to. So that part I can appreciate. I also can appreciate the fact that she had some mental health challenges that were going on that required her to be hospitalized, whether she did it herself or whether she was picked up because there was a mental health order. I'm not sure which one of those occurred, but the reality is that they don't allow you to stay in those facilities unless they find that there's a need for that to occur. So she was, if that is actually true, which I agree with Ms. McDuffie, we need to have some documentation of that. So that's the first piece. She needs to provide some documentation of that in those particular facilities. Secondly, she needs to test today, immediately, before 5 o'clock, ETG test. If she ETG just positive, she's going to be incarcerated at this point. Ma'am, are you going to test clean or positive for alcohol for the past 5 or 6 days?
Clean. I can assure you of that.
Your Honor, Ms. Dillon knows that she doesn't have any money for testing.
Well, and I guess she's going to do some jail time.
That she'll call her out.
I'm not playing. You test today or you go to jail.
Yes, Your Honor. Show you proof. I took pictures of my hospitalization paper.
You need to provide those to your attorney, who will then provide them to the prosecutor and the probation department, who will provide them to me. Okay?
Okay.
Yes. What are we doing with respect to the pretrial today?
We can get an adjournment, so I'm sorry.
I understand that Ms. White is new to this case and does need to adjourn, and that's fine. But I think Ms. Gelormino may need to be arraigned on the amended complaint because there is a new maximum penalty. And I also corrected the prompts for the existing charges as well.
You corrected the what?
The prompts.
All right. Let's see. All right. I am jumping off camera and letting this video play out. There's about 6 minutes left. I'm redirecting to Biggin because he's live right now. I don't know if he's still going to be live by the time I'm finished. I don't know. If you haven't already, please like and subscribe. If you haven't done your jump kick backflips yet, please do them. And if you would like to donate, my link tree is in the description. Please and thank you. I very much appreciate it. I put a lot of time in this, and I'm not monetized. So, yeah. Hi, Bob. How are you doing, Bob? All right. I guess, yeah, that's it. Let's go watch Biggin for a little bit after this. Until next time. Bye.
The descriptions were inaccurate, so I corrected those as well for the child abuse and charges.
All right, so the amended complaint in this case has count 1, child abuse 4th degree, which is up to 1 year. Count 2, child abuse 4th degree, up to 1 year. Count 3, assault and/or assault and battery, which is a maximum of 93 days and/or $500 fine. And then attempted police officer assaulting and resisting, which has a maximum up to 1 year and $1,000 fine plus court costs. So there are a total of 4 counts.
A formal reading of the complaint standing.
Thank you. I'm gonna continue what she was. I just needed to advise her. She's already been arraigned on the original one, so the
Okay.
same plea will continue, but thank you.
Phil, you're awesome. I appreciate you being here. He deserved to call up. He's special.
I'm gonna schedule this for December the 4th, 2024 at 10 o'clock a.m. in person. 2023 at 11 o'clock a.m. again in person, so that I will find out whether or not she's been drinking or what she's been doing. And I need to have that documentation then, and hopefully we have a better idea of what we're gonna do. And the bench warrant in this case will be recalled for today. I will reinstate it if she doesn't show up or if she tests positive.
Thank you.
You need to go there today, ma'am, like I said, and test. Okay? Yeah.
Oh, Ronna, I'm sorry, one more thing. If she tests negative for that ETG, is her SoberLink order, underlying order still, yeah.
Yes.
Okay, so she needs that back.
Yes.
Okay.
She has to test daily.
They're gonna give you the sober back. You gotta test it.
I thought she said if I.
You have to
Okay.
test today, and then you're gonna get this device back. Thank you.
You're welcome. And you're gonna work with her on getting a treatment because apparently she needs that. Thank you.